The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. Welcome to the Fourth Circuit. We're pleased to be joined this morning by our colleague, Judge Rushing, who has survived all of the problems that Asheville, North Carolina has had recently. So she'll be on screen, and if you hear Judge Rushing speak or raise her hand, the lawyers will stop so she can ask a question. We'll take up our first case, Amazon versus WDC Holdings. Mr. Hunger.
Thank you, Your Honor, and may it please the court. The district court's decision should be reversed and the case remanded for trial on Amazon's RICO, fraud, unjust enrichment, conversion, and conspiracy claims. On RICO and fraud injury, the law is clear that a jury can infer damages in the amount of the kickbacks paid to corrupt employees in a commercial bribery case. As the Dobbs Treatise explains, it may be assumed that the briber would have sold at a lower price if he had not had to pay the bribe.
So are you arguing for a per se rule where kickbacks are involved, or is that separately a matter of proof?
It's a matter of proof, Your Honor. We didn't move for summary judgment, but the district court, of course, granted summary judgment against us, and our point is the evidence in a commercial bribery case where it's shown, where there's evidence from which the jury can find that a bribe was paid in order to steer contract to the bribe payer, that it's a reasonable basis for the jury to conclude, based on the fact that the bribe was paid, that the bribe payer got at least that amount of benefit out of the fraud, and therefore there may be other evidence from which additional damages could be found, but that's certainly a reasonable basis
So
for a
is your
jury.
method of proof here that you would have an expert testify as to the differential in value, not based, for instance, on a real estate appraisal, but based on other economic factors?
Well, the expert, as we've cited in our brief, our damages expert does opine, in this case, that the bribes resulted in damage to Amazon because, but for the bribes, Amazon would have been able to do the transactions at a lower price. But again, the rule of law that we're articulating and identifying in the cases, and this is not just the Dobbs Treatise, this court has recognized it in cases involving Maryland law, in the Western contracting case. Other circuits have recognized it in the cases that we've cited in our briefs, including the Continental case and the Williams against Garrity case. The Virginia courts have recognized it in the Millborough case and the Jordan case and the Byrd case.
Am I correct here? The district court's decision was based on its finding that Virginia law required, in essence, appraisals of real estate values as opposed to any other kind of form of proof.
Yes, it adopted a categorical rule that's kind of required across the board in any fraud case, and that's the rule in a case where you buy a house and the representation was the roof doesn't leak, and in fact it does. But that's a very different scenario from a commercial bribery case. And in the commercial bribery context, Millborough and Jordan from the Virginia Supreme Court and the Byrd case from the circuit courts that we cite in our briefs all support the proposition that the bribe can be recovered and is an appropriate consideration in assessing damages and finding injury. And that's all we're asking for the court to send this back for trial so that the jury can consider the evidence and conclude, based on these principles of common sense and case law, that an injury exists here. Separate and apart from the kickbacks, which we believe in and of themselves establish injury and therefore require reversal of the summary judgment, it's also the case that there is specific evidence of ways in which the fraudulent conduct of Nelson and Kirshner and the other defendants inflated the costs that Amazon ended up paying. For instance, there's evidence, as we detailed in our brief, that they inflated the lease fees on the transactions in order to fund the kickbacks. But for the fraud, of course, there would have been no need to, and no basis for employees of Amazon to be trying to inflate Amazon's costs. So had they been doing their duty instead of breaching their duty of loyalty. Those are injuries to Amazon, unquestionably. The defendants don't even respond to that evidence in their brief. So that, again, standing alone requires reversal here. We also identified in our brief the rebates that were owed to Amazon from the broker on these transactions, but were instead transferred to the defendants. The only response the defendants offered to that is nothing on the merits, but rather they claim they didn't know about this in time to respond. That's simply not true, as we showed at pages 29 and 30 of our opening brief. Amazon's supplemental disclosures specifically identified the amounts of kickbacks and funds transferred to North Star, the fraudulent developer entity, those full amounts that Amazon was seeking to recover. Those amounts unquestionably include the $700,000 or so in rebates. Similarly, Amazon identified in its supplemental disclosures the $5.1 million transferred from North Star to Villanova, the fraudulent entity set up to launder the proceeds. And that money unquestionably includes the $700,000 in rebates that we're seeking. They knew about that at the time, well before discovery closed. And we know they knew about it because after they received those supplemental disclosures, they sought discovery on the very rebate issue that we're talking about. So there's no question they knew about it, there was no prejudice or harm, and therefore no basis for excluding that evidence. Turning to the RICO enterprise issue, if the court has no further questions on damages, the district court committed reversible error in relying on the hub and spoke concept, which does not apply in the enterprise, to the RICO enterprise setting. In fact, as this court recognized in the Griffin case, the whole point of the RICO enterprise concept was to be easier to prove than a conspiracy. And both the Fifth Circuit and the Third Circuit have expressly rejected the notion that the hub and spoke or rimless wheel concept governs the enterprise. And in any event, even if it did apply here, which it doesn't, it would be satisfied. This is a far cry from what this court described in the Dixon case as a hub and spoke or rimless wheel conspiracy, namely one where the spokes have no connection with one another, but only separate agreements with one common defendant. Here, most of the defendants were involved in all of the 11 transactions, the fraudulent transactions at issue. Nelson, Kirshner, Atherton, and the Watson defendants. The Watson defendants admit they were involved in 9 of the 11. We believe they were involved and allege and have evidence that they were involved in 10 of the 11, since the 10th is the White Peaks transaction in which Mr. Watson pocketed $5 million on the theory that his employees had engineered that transaction. So it seems quite clear that there's a basis for connecting them to that as well. So this is when all of the defendants before the court were involved in the vast majority of the transactions engineered by the enterprise. This is a far cry from a rimless wheel conspiracy. And the district court's ruling on that issue should be reversed as well. Turning to the conspiracy issue, the district court dismissed the conspiracy claims against the corrupt lawyer, Atherton, on the theory that he was acting merely as a lawyer, and therefore the intra-corporate conspiracy doctrine or a single entity rule barred conspiracy liability. But of course,
You're gonna address the unjust enrichment and conversion claims?
yes, Your Honor. I'm happy to address those. With respect to those claims, we think this court's prior decision in the earlier appeal in this case compels rejection of the district court's reasoning, which was that legal remedies are adequate, therefore the equitable claims can proceed. That same argument was rejected last time around.
So did the district court violate the mandate rule here?
We think it did, yes, Your Honor, as to those equitable claims against the Watson defendants. And the principle of this court's ruling last time around applies to all the defendants before the court. But even aside from that, even putting aside the mandate rule, the district court's ruling was just wrong on the merits. We don't have to make an election until we see what the verdict is to determine whether legal or equitable remedies are more appropriate. And in fact, our equitable claims for relief are larger in monetary terms than the legal damages claims. So as a matter of law, it's erroneous to say that our legal remedies are adequate. The defendants argue that there are contractual bars to equitable relief here on the unjust enrichment claim, but that's simply not true. The Watson defendants aren't parties to the lease agreements. They weren't parties to the lease agreements even in the beginning. We originally sued them only on an alter ego theory, which they denied, and those claims are no longer in the case. They can hardly hide behind a contract that they deny being bound by, and this court so ruled in the previous appeal. And as for the agreements with the corrupt employees, those agreements don't cover the subject matter of this case at all. They were limited to specific confidentiality and non-competition provisions that the district court
Let's go back to the attorney criminal activity. What authority is there that would say that an attorney that engaged in criminal activity, how can he still be an agent? Is there authority for that?
None that I'm aware of, Your Honor. The authorities are quite clear in Virginia and elsewhere that for that doctrine, the intracorporate conspiracy doctrine, to apply, the agent has to be acting within the scope of the legitimate bona fide agency relationship. Here, the allegations are, and the evidence is, that Atherton was engaged in money laundering, hiding the proceeds of illicit activities and funneling them through a bunch of shell corporations and entities in order to deceive everyone and conceal the fact that Amazon employees were getting kickbacks on Amazon deals that they arranged. That's a far cry from legitimate legal representation. And in fact, as this court said in the United States against Farrell, that's precisely the kind of situation where a lawyer is liable as a conspirator. The court said, a lawyer representing or advising a criminal entity can readily turn himself into a co-conspirator in the form of a consigliere or fixer. That's precisely what Atherton was doing here, and therefore the district court's rejection of conspiracy liability for him on the ground that he was a lawyer is simply wrong, because the whole theory of the case is he was not acting as a lawyer. He joined in the frauds as a co-conspirator, engaging and facilitating in illegal
So is
activity.
it your argument that there's a factual dispute here about his capacity?
Yes, Your Honor, exactly right. And the Supreme Court, the Virginia Supreme Court in the Fox case and the circuit court in the PGS case that we cite recognize that in those circumstances a trial is necessary to resolve the question whether the attorney was acting or the agent was acting within the scope of his alleged agency. So for all those reasons, we ask that the judgment of the district court be reversed and the case remanded for trial. If the court has no further questions.
All right, thank you. You've got some rebuttal time.
Thank you.
Mr. Hudson?
Good morning, and may it please the court. This case is about 11 real estate transactions, 9 leases, and 2 direct purchases that Amazon carefully evaluated, that were made at competitive fair market rates, and that Amazon affirmed and has never sought to rescind. The operative complaint, Amazon's
I
fourth.
thought Amazon went back and basically redid all the leases and took North Star or some of the other defendants off of them.
There are 2 relevant contracts I think you're referring to, Your Honor. The first was a lease continuity agreement that did affirm the leases. That was in 2020. And then a year later, in December 2021, Amazon unilaterally, without North Star's participation, amended the leases. But importantly, and this is the critical point, Amazon has never sought to rescind the leases or any of the other transactions, even though that is an appropriate remedy in a
So
fraud
why would they
case.
need to do that?
What would they need to do to?
Why would they need to rescind the leases? Why is that important to your argument?
Because, Your Honor, if they believe that the leases were at unfair rates, that they were paying too much, they were deceived by their employees into overpaying, then they could have sought to rescind them. And indeed, they discovered this before they started making payments in almost all of the leases.
Well,
And-
here, wouldn't the same effect be arranged if they got the damages that Revived's leases would have given them from your clients?
I'm sorry, I'm not following your question, Your Honor.
Well, I mean, instead of revising the lease, the amount they think they overpaid, they're suing your clients for.
That's right, Your Honor. That's exactly right. And that is the allegation they made in the operative complaint, that they overpaid for all of these transactions. And when this case reached the summary judgment stage, the district court concluded that Amazon completely failed to substantiate their allegations in their operative complaint. First, the district court found, and Amazon doesn't dispute on appeal, that Mr. Watson had no involvement with the direct purchases. Nor did Amazon provide any evidence that it overpaid in any of the transactions. It even admits that it presented no evidence of any of the transactions' fair market value.
I thought your opposing counsel said it had expert witness testimony that did demonstrate they had overpaid.
Your Honor, Amazon has no expert witness testimony. Amazon's expert witness repeatedly and explicitly testified that he was not offering an opinion on damages. Quote, "I'm not offering any opinion on damages, period." That's Joint Appendix 3287. "I was not asked to opine on Amazon's recoverable damages at all." That's Joint Appendix 2433. "I'm not opining on Amazon's damages related to any count." Joint Appendix
Counsel,
3291.
isn't an expert to opine on damages? It's kind of a different question, isn't it, than whether they have substantiated an injury, right? I thought the district court said there was no evidence from which a jury could find Amazon had been injured in its business or property, and that's why it was thrown out, not that they hadn't put forward a proper damages expert.
That's correct, Your Honor. There is a potential distinction, at least in some cases, between the existence of an injury and damages, although oftentimes the evidence will overlap substantially. And you're right, in this case, the district court concluded Amazon failed to provide any evidence from which a jury could reasonably conclude that Amazon was injured, as is required by the Civil RICO statute and their Virginia law fraud claim. And the district court said, one, I have no expert evidence on this question, because the expert said, I'm not testifying to whether they overpaid.
I thought the district court said there was not evidence of injury because evidence of fair market value is required. Not that the expert claimed to be saying nothing, but that the expert wasn't relying on fair market value.
No, Your Honor. The critical point for the district court, now there are, I think, 2 points here. One, with respect to the expert, the district court concluded the expert simply doesn't speak to this question. The expert's report simply traces the path of funds, which is fine. That's an appropriate role for the expert. But the expert did not testify about overpayment because, of course, the expert couldn't testify about the fair market value. The expert declined to do so. Nor, critically, did the expert testify about causation, that the referral fees caused higher rates than would otherwise be the case. The expert did not testify to that. There's no basis in the expert's report for that conclusion. So the district court said, okay, we don't have expert evidence. Okay, so what other evidence do we have? And my friend on the other side.
So your position is that the jury could not infer an injury from the kickbacks?
Yes, that is correct, Your Honor. And that conclusion is required by this court's decision in Bear versus Craig Northrop, which was at a motion to dismiss stage, which is all the more the case. So in Bear versus Craig Northrop, there were alleged kickbacks. The title insurance company allegedly paid kickbacks in the form of marketing fees to the real estate brokerage. And the complaint alleged that that caused them to pay more than they otherwise would. And the court said there are no specific allegations. The existence of the kickbacks themselves don't make it plausible that you paid more than you otherwise would. And that's at the motion to dismiss stage.
We're not talking about just a complaint here. There's evidence in the record about, they're pointing out the rebates, this other evidence. There's a lot more going on than just an allegation. Can you address that?
Yes, Your Honor, thank you. So I think it's helpful to break this up into 3 pieces. So one, we have the suggestion, the argument that you just referred to, that the kickbacks themselves are ipso facto evidence that would allow a jury to find an injury. And Bear forecloses that notion, because if that were the case, Bear would have come out differently. You would have at least made it plausible, the existence of the kickbacks in the Bear case, to create an injury for Article 3 purposes. So Bear, I think, forecloses that notion. Then we have the rebates. And the district court properly concluded that Amazon forfeited its reliance on those rebates. Amazon was aware of them from the beginning. They did not allege anything about them in the complaint, nor did they raise anything about them in their Rule 26 disclosures. And the important thing, I think, on the rebates is to recognize the rebates are not simply another form or an expansion of, say, consequential damages. This isn't a fender bender where the plaintiff says, oh, I initially thought it was just my shoulder, but it's actually my back too. That's not the situation here. The rebates involve entirely new, potentially wrongful conduct. And, for example, the rebates are only a valid form of injury if Amazon was actually entitled to those rebates. And it's still not clear to me, even now on appeal, what the source is of that legal entitlement. Is it a written contract? Is it an oral understanding between Amazon and the broker? It's still not clear. And certainly Amazon didn't allege anything like that in its complaint. And this court has been consistently clear that a party is not entitled to unilaterally amend its complaint by raising new theories and new facts in its summary judgment opposition. So that's the rebates. So now we have what I think is the final category of evidence that Amazon relies on, which are a few internal messages between Mr. Watson and some of his employees. And the critical thing is those emails or messages simply discuss Mr. Watson's negotiating strategy. Like what do we think? And again, so those are with non-Amazon employees for the most part, Mr. Ramps there. And those are just about, well, what do we think? How should we charge Amazon? What is the amount? None of that evidence, and this is the critical point, draws a connection between the referral fees and higher prices. And so this gets to the question that Judge Agee asked my friend on the other side, and that is there a per se rule here? And we're not asking for a per se rule either. I mean, there's lots of evidence that a plaintiff could potentially use to establish damages in a kickback case. The plaintiff could point to, Amazon could have pointed to its own internal transactions. How do these leases compare to its other leases, again, with other counterparties? It had all of Northstar's evidence. It could have looked at other Northstar transactions. It could have had an expert. It could have looked at internal documents that actually do show a connection between the kickbacks and higher costs. And in many kickback cases, and say in the municipal context, there are oftentimes cost-plus contracts where any additional cost automatically, by operation of the contract, increases the price that the purchaser paid. That's not what we have here. These are maximum gross price contracts where Amazon's paying the rent number, period, regardless of how much it ultimately costs Northstar to do the build-to-suit transaction. And then the last point I'll make on the damages piece, Your Honor, is none of the evidence, the messages that Amazon cites.
Wasn't there evidence that these kickbacks entered into the computation for what the rental amount was?
No, Your Honor, there is no evidence of that, and that's the critical point. The evidence they have is Mr. Watson included items in the budget, so say a 2% lease fee. And that's very common. Amazon doesn't dispute that that's very common. And all of those are visible to Amazon. It can see it in the budget, and then a yield, a percentage is applied to that total budget, and that produces the bottom line rent payment. And that's what Amazon pays. And
But if the kickback amounts are included in some of those components, why wouldn't that be sufficient proof, at least for summary judgment purposes?
precisely, Your Honor, if Amazon could show that the referral fees were increased, the existence of the referral fees increased, say, the 2% leasing fee. If they had evidence that Mr. Watson,
What would happen if the referral fee was 1%, but the kickback bumped it up to 2%?
precisely, Your Honor, I think that's right. Like, that's precisely the evidence that Amazon needs, and that's precisely the evidence they don't have. It's speculation. We know that referral fees were paid, but we don't know that the existence of the referral fees actually increased any dollar amount in these contracts. We just don't have it.
Isn't
And
that part of what the expert says? He says if the scheme did not exist, Northstar wouldn't have had to charge these fees and could have made the same profit. And so the overall lease budget would have been lower and Amazon's rent would have been lower.
And Your Honor, first of all, the expert later disclaimed any opinion on this notion. Two, that's speculation. It is entirely, we have no dispute with the general notion that the payment of referral fees, the payment of kickbacks can in some instances increase the price that the buyer pays. But what Amazon needed at summary judgment was specific evidence establishing that point. And the last point I'll make on the damages piece, on the RICO injury piece, is none of the evidence that Amazon cites has anything to do with the purchases. All of the messages that they cite refer to the leases. So at the very least, they failed to prove any civil RICO claims or fraud claims as to the leases. And then the final thing on the fraud claim, Amazon doesn't dispute that its fraud claim is subject to a higher evidentiary standard, clear and convincing evidence. So even if the court thinks that Amazon has squeaked past the line to establish injury on its civil RICO claim, it has not done so. The district court properly concluded it failed to do so on its fraud claim. And in addition, as we pointed out in our brief, Amazon forfeited any arguments as to its fraud claim because it didn't respond to this point at all in its summary judgment opposition. The district court correctly found that. And this is not just, a ticky-tacky, well, you should have repeated these arguments in the fraud section of your summary judgment brief. The fraud claim has a different source of law and a different evidentiary standard. And Amazon needed to address that standard in its summary judgment brief, and it failed to do so. So turning very briefly to, unless the court has any questions on enterprise, I'll turn to the equitable claims. The Amazon does not argue, I think correctly, that this court's preliminary injunction opinion has any effect on its equitable claims as to Mr. Nelson and Mr. Kirshner. They weren't parties in that case, in that appeal, of course. They weren't parties in the case at that time, and of course the court had no occasion to address the significance of their employment agreements, the CNIAAs, on Amazon's equitable claims. And Amazon now says that their employment agreements had nothing to do with the subject matter of this case. But that hasn't been Amazon's position. Amazon raised a breach of contract claim in this case.
Well, I thought the district court's ruling was that you have a claim for damages, therefore you cannot make a claim for unjust enrichment or conversion.
That was one theory the district court raised, Your Honor, and we have not pressed that theory on appeal. So instead...
So that would appear to, if you had, that would appear to directly violate the mandate rule.
At least with respect to Mr. Watson, Your Honor. I think that's fair, yes. But we aren't pressing that argument. I think the direct argument here arises directly from the Virginia Supreme Court's recent decision in the James G. Davis construction case. It's a clear rule of law. When the existence of an express contract covering the same subject matter of the party's dispute precludes a claim for unjust enrichment. And the Virginia Supreme Court, in announcing that rule, expressly adopts the position of the restatement. And Amazon relies on a single exception to this rule, which is whether or not the contract covers the same subject matter of the party's dispute. And the restatement is crystal clear that that exception is not triggered simply because the plaintiff lost their breach of contract claim. It's not as if, under the restatement's approach, if you bring a breach of contract claim and you lose, well, then you can rely on equitable theories. That's not the restatement's approach, and there's a good reason for that. As this court recognized in the Raymond Colsar case from 1992, in recognizing the Virginia Supreme Court's rule on this point, parties to an express contract are entitled to have their rights and duties adjudicated exclusively by its terms. Mr. Nelson and Mr. Kirshner had contracts with Amazon. They specified their obligations.
Did they cover bribes and kickbacks?
They did not. The district court concluded that they did not cover bribes and kickbacks, and it ruled against Amazon on its breach of contract claim. Amazon previously argued that it did. The district court disagreed, and Amazon has not disputed that finding on appeal. And so that squarely forecloses Amazon's equitable claims as to Mr. Nelson and Mr. Kirshner. And with respect to Mr. Watson, I think the critical difference between the posture of this case now and when this case was on appeal previously, as this court emphasized in its complaint, the operative complaint during the PI appeal, Amazon argued that Mr. Watson was liable not just on the leases but on the direct purchase. And the district court concluded, after hearing evidence on summary judgment, that there is no evidence to support that. And Amazon hasn't seriously disputed that on appeal. And so now, the only contracts that form the basis of Amazon's unjust enrichment claim are the leases. Those leases cover this conduct, as Amazon previously argued. It bars its unjust enrichment, its equitable claims.
All right. Thank you, Mr. Hudson. Ms.
Thank you.
Palmer, have you got something to add?
Good morning. May it please the court. I'm Julie Palmer, and I represent Rodney Atherton. In addition to adopting Mr. Hudson's arguments, I want to address the district court's ruling on the intracorporate immunity doctrine. The district court correctly held that that doctrine barred Amazon's claim for civil conspiracy against Mr. Atherton under Virginia law. In the first instance, the district court correctly held that
So if an
Amazon...
attorney engages in a criminal conspiracy, even though if that is an aid of one of his clients, do you say they're immune from a conspiracy action?
Well, I think the question is, does the doctrine apply? And the way that the courts have looked at this exception is, were the acts of the attorney authorized by the client? So if those actions were authorized, then yes, I believe the doctrine, as the Virginia Supreme Court has set it forward,
Right, but isn't
does
that
apply.
a factual question as to what the lawyer did? And that the evidence is in conflict on whether or not he was acting solely as counsel for his clients or whether he was an active participant in a fraudulent transaction for which he made money?
I think we need to separate out the RICO conspiracy claim from the Virginia law conspiracy claim, because what the district court applied the intracorporate immunity doctrine to was the Virginia law civil conspiracy claim. That's what was in the district court's opinion, and that's what Amazon is appealing. There is case law that addresses in the RICO context whether an attorney's actions go beyond the bounds of proper attorney conduct so as to turn them into potential liability for RICO. That's not what the court ruled upon. The court didn't apply the intracorporate immunity doctrine to the RICO claims against Mr. Atherton. It ordered summary judgment in his favor based upon all the other reasons. It actually never addressed the argument about whether the allegations or the evidence of what Mr. Atherton did crossed that line from attorney conduct over into fraudulent or criminal conduct. And so it never...
Isn't that the issue?
Not as to the civil conspiracy claim under Virginia law. The sole issue there is whether there is evidence that Mr. Atherton conspired with anyone other than his clients, because the principal cannot conspire with his agent, attorney cannot conspire with his client. The Amazon points to two potential exceptions to that rule before this court. Importantly, they never pressed those issues before the district court, nor did the district court pass upon the application of either of these two exceptions. So the district court properly held that the intracorporate immunity doctrine applied, and Amazon did not preserve that question for appeal. If, however, this court were to get to the merits of that, neither exception applies to Mr. Atherton's conduct in this case. First of all, as to the outside of the scope of his attorney conduct, this court has never recognized such an exception to the intracorporate immunity doctrine. Moreover, all of the allegations that Amazon put forward with regard to Mr. Atherton did relate to his conduct as an attorney. That was what was alleged in the third amended complaint, and it was also, importantly, there was no evidence to the contrary presented to the district court at summary judgment. So for those additional reasons, we ask that you affirm the district court.
All right, thank you very much.
Thank you.
Mr. Hunger, you've got some rebuttal time.
Thank you, Your Honor. Several hopefully brief points. First of all, counsel argued that the lease continuity agreement affirmed the leases. That's not correct. In fact, what the lease continuity agreement did was terminate any involvement by Watson and North Star. They had never been parties to the leases, but whatever connection they had was terminated by pursuant to the lease continuity agreement, where IPI, the entity that provided the funding for the leases, and Amazon agreed that Watson and North Star would be terminated because of their fraud. So to the extent rescission is even relevant, since they weren't even parties in the first place, their relationship was agreed to be terminated by virtue of that agreement. We do dispute that Watson, the counsel claimed that we concede that Watson had no involvement in either of the purchase transactions. That's simply not true, as I argued before. Watson pocketed $5 million out of the White Peaks transaction on the ground, as he claimed that he was entitled to share in the illicit proceeds because his employees had negotiated that deal, and he got $5 million. The Bear case is completely inapposite here. The counsel argues that there were overpayments alleged in that case. To the contrary, this court said in Bear, and I quote from page 254, "The Bears do not contend that they were harmed by being overcharged for settlement services," close quote. So both for that reason and because, as the court went out of its way to say in Bear, there was no fiduciary duty at issue in that case is completely inapposite, since this case does involve breaches of the fiduciary duty of loyalty owed by Nelson and Kirshner to their employer. On the KBC rebates, I already explained why our supplemental disclosures identified the very $5.1 million transferred from North Star to Villanova that were being claimed as monetary harm, and that it is undisputed, includes the rebate amount, and defendants well knew that since they're the ones who directed that the rebates be transferred to North Star, and from North Star to Villanova, and from Villanova through sham entities to Kirshner and Nelson. So there was no dispute. Not only did they seek discovery on that question before fact discovery closed, the expert, the damages expert that our damages expert report explicitly addresses the KBC issue at pages 2433 to 35 and 2472 of the joint appendix. They deposed him on that very issue at length, as we've shown in the brief. So there was zero surprise, zero prejudice, zero basis for excluding that evidence. On damages, as I said before, counsel here today at oral argument is trying to offer a belated defense, claiming that in fact there's no evidence of a connection between the fraudulent conduct and inflated costs separate and apart from the kickbacks. As I said in my opening remarks, we went through all of that in our opening brief at pages 8 to 10 and 24 to 26, citing record evidence in great detail, showing the various ways in which the fraudulent conduct of the co-conspirators inflated the budgets, the leasing fees, the yield rates, and other expenditures that were built into the budget amounts that then the yield rate was applied to determine Amazon's rent. So it's unquestioned that, in fact, there was evidence from which the jury could find that Amazon's rents were increased by the conduct. They did not even respond to that in their appellee's brief. And for them to stand up today and claim there's no evidence, we submit should not be accepted by the court. The expert, as Judge Rushing pointed out, far from conceding that there was no evidence of injury, the expert said at page 2460 of the joint appendix, having gone through the evidence that I just articulated, he said, Amazon would have been able to negotiate for lower lease rates, and the overall lease budget and Amazon's rent would have been lower had the portion of North Star's fees paid to Villanova Trust been eliminated. That is, the fraudulently increased fees. That's at page 2460. The counsel makes much about the expert's unwillingness to opine on, quote, damages. The expert was simply trying to avoid opining on a question for the jury, to avoid a Daubert challenge that he was opining on something beyond his expertise. What he said was, repeatedly, and his ultimate opinion is, Amazon suffered economic injury to the tune of many millions of dollars. Economic injury is a basis to get to the jury. Counsel argued that we somehow waived the fraud argument. That's simply not correct. If the court looks at pages 624 to 625 and 630 to 633 of the joint appendix, that's excerpts from our summary judgment opposition. We articulated our fundamental point at 624 to 625 that both fraud and RICO injury are established by kickbacks, as well as by the other evidence that I've articulated. And then we went through in greater detail in the RICO section at 630 to 33, addressing all of the other side's arguments. It's true we didn't cite every single case they cite and go through them case by case, but we said their state law cases are irrelevant because those are all, as I said before, mere simple real estate purchases where there was a misrepresentation about some of the quality of the land being purchased. It wasn't a commercial bribery case, and so they're inapposite. We didn't reiterate all of that in the fraud section. It's true because it had already been set forth. The district judge was well aware of our arguments and proceeded to explain in great detail on the merits why he thought our position was wrong on fraud. So there was no waiver, and the judgment should be reversed. I think the final point I wanted to address was on the equity claim, the equity arguments. Raymond, this court's decision in Raymond says that a contract will foreclose unjust enrichment claims if the parties expressly delineated the contractual obligations the two will have on the subject in question. The agreements with the employees say nothing about fraud, fiduciary duty. They're not employment agreements. They don't specify the terms and conditions of employment. They don't, other than the limited issues they address. They don't specify the duties of the employees. They don't specify the salaries and benefits. They simply don't cover the conduct at issue here, and not even the district court said that they did. For all those reasons, we ask that the judgment of the district court.
Before you sit down, what do you say is the factual dispute with regard to the attorney Atherton? What takes that out of the summary judgment category and makes it a jury issue?
The factual dispute is whether the attorney was acting within the scope of his employment as an attorney, that is actually providing bona fide legal representation and bona fide legal advice, or instead had become a participant in the fraud and conspiracy. And as this court said, counsel said there's no case recognizing, but it's simply not true. Both the Virginia court and the CGI, different issue. So the Virginia court in the PJS case that we cite in our brief, the Virginia Circuit Court, and this court in the Farrell case, recognize that a lawyer who is not providing bona fide legal representation, acting truly as a lawyer, but instead is participating in illicit conduct, can become a co-conspirator. And because they're acting outside the scope of a bona fide attorney-client relationship, that's the factual issue for the jury to decide.
All right.
Thank you.
Thank you very much. All right. Well, obviously, Judge Rushing can't come down and shake your hand, but Judge Floyd and I will, so we'll be down momentarily. All right, please be seated. All right, our next case is Kogi versus NSO Group. Mr. Quirk.
May it please the court. The district court committed reversible error in holding that it lacked specific personal jurisdiction over defendants with respect to the plaintiff's claims that defendants accessed and obtained information from her electronic devices in Virginia. The district court's finding of no jurisdiction turned primarily on the first prong of the constitutional test, whether the defendants availed themselves of the opportunity of conducting activities in the forum state. This court has recognized since the ALS scan decision that a defendant's activity in the forum can be conducted electronically, and has recognized since at least Care First of Maryland that even a single contact may be sufficient to establish jurisdiction when the contact arises out, when the cause of action arises out of the single contact. That's this case. The federal law claim under the CFAA covers whoever intentionally accesses a computer without authorization and thereby obtains information from any computer. That happened here in Virginia. the defendants purposefully committed these acts by accessing Ms. Khashoggi's electronic devices and obtaining the information from them and routing them through their system
So
back to.
how did they do that, and where is that? Give me your best paragraphs that allege that in the complaint.
There are a number, but on JA 56 in the defendant's client service manual, they represent that Pegasus provides
Right,
unlimited.
what I'll need from you is the paragraphs in the complaint that make the allegation of actions by the defendant that establish personal jurisdiction.
Okay, and so the allegation is that the defendants operate this system that accesses the target's devices, and the allegations that the plaintiff.
Well, I know that
and-
there are allegations that the United Arab Emirates or perhaps Saudi Arabia did that, but where are the allegations that this defendant did it?
So this comes from the attachment to the complaint, the service manual that demonstrates the defendant's involvement and participation
All right,
in the
let's
accessing
go back
process.
again. Give me the paragraph in the complaint that gets you there.
So in paragraph 34, we allege that defendants engaged in conduct in Virginia by using the plaintiff's device. And that's our jurisdiction allegation. And where that allegation comes from is the defendant's operation of the system that accesses the device where it is. We plead at paragraphs 15, 110, and 111 that Ms. Khashoggi was present and living in Virginia after her marriage to Jamal Khashoggi, and that during this time, the accessing of her devices occurred there. And so the defendant's participation in this process comes from, there are allegations in the complaint and then allegations in the record evidence. At paragraph 60 of the complaint at JA 20, we quote a defendant's statement to the press that NSO can identify and stop misuse and shut down the system. This is part of the reason that while the system is
So how does
operating.
that show that they acted in Virginia?
It shows that because that's where the devices were. And
Right, but there's no allegation that I can see that it says, even though they might have this capacity, that this is what they did, and they did it in Virginia.
so the allegations, the support for that conclusion comes from the exhibit to the complaint, which shows how their system operates, and it also comes from their representations in there. At JA 77, the defendants represent to their foreign state clients that in the event of an exposure risk, we will automatically shut down the Pegasus system, so that in the event that there's a risk of them getting caught, defendants, not the foreign state, will shut down the system. So the defendants are involved in the system's continued operation until it's shut
Right,
down.
I understand from a 30,000-foot perspective that that's what they can do. I'm still having trouble finding where in the complaint you say they did this and they did it in Virginia.
So they did it in Virginia comes from the paragraph's reference that that's where the plaintiff and her devices were. The allegation that they did this is this is the system that was found on her devices. And it's a system that throughout their service manual, they illustrate their control and their involvement in the system's operation. And so,
So you have that she's in Virginia with her device and allegations that the device is monitored consistently such that we can plausibly infer that while she was in Virginia, it was monitored or data was extracted. But the disconnect comes at where are the plausible allegations that the defendants did the extracting in Virginia, right? There's lots of allegations that the defendants can get a report immediately when data is available, or that they have ways to manage their system. But where is the allegation that the defendants do the extraction? That's the reaching into Virginia that seems relevant here.
and so, I mean, an illustration of this is at JA 69, the figure 5, which maps out how the system works. And it shows a sequence of steps, the first of which is the device in Virginia, the next of which are a series of servers that the defendants operate, and then the last of which is the information reaching the clients overseas. And so that
shows that maybe that they could do it. But I think what we're looking for is where in actuality did they do it?
And there's all there is the representation that their system doesn't operate in the United States. Our expert, Dr. Marczak, rebutted that by showing that this hasn't been demonstrated, this would be highly difficult to accomplish, and that in fact the Pegasus system has been used on devices, on at least one device, if not more, in the United States. So in that sense, the defendants are the ones operating there in order for the data on the device, the information on the device in Virginia, to get from the device through the defendant's server system to the foreign state client on the other end. And so the representations that defendants make in their service manual, since agent installation and data are transferred over public networks, we make sure it is transferred in the most efficient and secured way all the way back to the customer's servers. That's at JA 79. That's defendants putting themselves in the transmission from the device all the way back to the defendant's, the client server on the other end. If I could turn briefly to the immunity question that the district court decided favorably to the plaintiff.
And so that's the defendant's cross appeal issue. Am I right on that?
Right. It's the position that we say and they said is an alternative grounds for affirmance.
Right.
They say it's a cross appeal issue.
So it's up to you. If you want to address that now, you can, but you have rebuttal, and if they raise it in their argument and you wanted to address it in your rebuttal, you could. But that's you can decide how you wish to pursue that.
Well, since they raised it in their principal appellate brief, they raised it as a grounds for affirmance of the decision. I'll address it now. There is no common law immunity for foreign independent corporate entities in light of the FSIA. This is what the Ninth Circuit ruled in the WhatsApp decision. The FSIA defines a foreign state to include an agency or instrumentality. It then defines an agency or instrumentality with a three-part definition, two of which the defendants don't satisfy. First, it must be a separate legal person, including a corporate entity. The defendants satisfy that. It must also be an organ of or majority owned by the state or its subdivision. Defendants are not owned by or an organ of the states that they were operating for here. And finally, to be a state entity, the defendant must be not a U.S. citizen and not created by a third country. Here, defendants were created by a third country, Israel. Since the defendants don't satisfy Congress's specific criteria to be a state-connected entity, a state agency or instrumentality, they don't have a claim to immunity, and the district court decided this question correctly. If I could finally address the cross-appeal issue, why this is an opposition argument, it's not a cross-appeal argument. Okay. The defendants won. They obtained dismissal with prejudice. When defendants filed their principal appellate brief, they recognized that they argued that this court should affirm the dismissal of plaintiff's complaint, either for lack of personal jurisdiction or, in the alternative, for lack of subject matter jurisdiction. They admitted this is an alternative grounds for affirmance. This court ruled in the Harriman and BPJ cases just this year. Alternative grounds for affirmance do not provide the right to a cross-appeal, and to the extent there's no right to a cross-appeal, theirs should be dismissed.
Okay.
There are no further questions.
All right. You've got some rebuttal time, so we'll hear from you again. Mr. Parrish?
Thank you, Your Honor.
As I understand the docket, that you would have rebuttal time as to this foreign sovereign immunity question if you wish to take it after the plaintiff's rebuttal.
Yes, Your Honor, and I've asked to reserve a few minutes of my time, if I may.
All right, thank you.
So, thank you, Your Honors. May it please the Court. I want to start with your questions because you are correct. There's no allegations of conduct here directed at Virginia, and Judge Brinkema, in her very careful decision, was correct about that as well. Now, Your Honor, you asked, what are the paragraphs in the complaint? And he said to you this morning, it's paragraphs 35 and 110 to 111. If you look at those paragraphs, with the exception of a conclusory assertion in paragraph 35, it is all focused on the allegations of where plaintiff was and what plaintiff was doing. But we know from Walden v. Fuhr in the Supreme Court that establishing purposeful availment is not focused on the plaintiff, but the defendant's conduct. And there just isn't enough. Now, Your Honors, the way that they've pivoted a little bit on appeal and before you today is to say, well, this is about surveillance and electronic monitoring, and therefore, as long as there was some data retrieved, and you should just speculate that that happened, that's enough. But, Your Honors, you notice that he did not say to you what the standard is under this court's precedents, which is under this court's precedents, it's very clear, not only must there be a cause of action, there also must be manifest intent. And so the manifest intent is essential because it cannot just be the unilateral conduct of the plaintiff that causes the connections to Virginia. There must be allegations specific to the manifest intent for our client to have targeted Virginia, and there just is nothing like that here.
The manifest intent cases seem to me to mostly be about a defendant running a web page, that's available all around the world, and we say, we have to show that there was an intent to reach into a certain state, not just that the plaintiff looked at your website in the state. But here we have an intentional tort, which seems different. It has its own intent, requirement. But why doesn't that make the manifest intent cases a little distinguishable?
Well, Your Honor, we do agree with you that they are distinguishable in the sense that we think that this is their attempt to try to say that there's a special standard here for personal jurisdiction that otherwise they just don't meet. So in one sense, we completely agree with Your Honor that those cases really don't apply. But to the extent that you want to address their alternative argument, that as long as there's some, as they put it, sort of a first interception and collection of data that happens in Virginia. Now, there's no allegations in the complaint that actually substantiate that, but that's their theory. We would at least say, Your Honor, that if you're going to apply those cases as they ask you to, that you would apply the manifest intent standard. Your Honor, going to perhaps an implied part of your question there, or sub-part of it, relates to the idea this is an intentional tort, but I do think Judge Brinkema was absolutely correct in thinking the difference between the cases that they really haven't cited to you anymore, but they did cite below to her, which is all of those cases were direct actions where the allegations were that a specific actor engaged in specific conduct targeted at Virginia. So in the case of the Russian person who was exercising a website. But here, the allegations are just the opposite. The allegations are that Saudi Arabia and the Emirates installed or tried to install the program in the Emirates and in Saudi Arabia, not in Virginia. And there's no evidence that her phones were ever accessed, no allegations that they were ever accessed in Virginia. So all there is the speculation that actually the installation worked, that then when it came to Virginia, that she did unilaterally, that on itself then meant that there was continuing monitoring. But there's no allegations.
Am I recalling correctly that there is an allegation in the complaint that the software was implanted in her phone in Dubai?
That's what they allege.
Right.
Yeah.
Okay.
So Your Honor,
There's no allegation that it was implanted in Virginia.
that's exactly right, Your Honor. And Your Honor, I just say this because I don't think we need to get there, but the undisputed record evidence is on JA 95, which is that this program doesn't operate in the United States. Now, he said that was rebutted by Dr. Marzak at JA 136. But if you take a look at that declaration, you will see that Dr. Marzak says, we weren't able to tell whether Pegasus was even ever installed on her phone. And then he raises sort of three questions that he has about whether it might be possible to operate in the United States. So he says, look, there's some suggestions that the app has been presented to the FBI, and in that context, maybe it operated. We don't know for certain because we haven't fully analyzed whether it might have operated, and we don't know whether some data might have gone through, notwithstanding all of the restrictions. None of that is sufficient to carry their burden, particularly given the fact that there's nothing in the complaint that substantiates this. This is just after the fact attempt to add to the complaint.
Well, we're at the stage where we're assessing a complaint, so we have to take the supported allegations as true. How can we credit the defendant's assertion that this program never works in the United States when plaintiff says it does? The plaintiff cites the WhatsApp litigation where a 202 phone number was targeted. You would get to prove whether that's true eventually, but how can we credit your assertion over hers at this point?
Well, Your Honor, I would say two things, which is that you don't need to get to any of this if you just look at the complaint and recognize that she hasn't pled enough to actually show that there's anything. To the extent that you're willing to consider the additional materials that she wants to rely on outside of the complaint, and you want to treat this as more of an evidentiary showing, all I would say is that the evidence is unrebutted that was presented to the district court. So, Your Honor, I'm not suggesting you need to rely on it, but I am asking for sort of parity, and the idea being is that there's nothing in the complaint to the extent they're trying to supplement by looking at evidence, and you want to think of it in those terms, then the evidence cuts in our direction, not in hers. So Your Honors, I'm not sure what else I need to say about this because it really, Judge Brinkema did a very good job of walking through the fact that if you're going to allege, there needs to at least be an allegation that somehow we were involved in accessing the phones. We weren't, that actually happened in Virginia. There's no allegations about that. That there was some conduct that we directed towards Virginia. There's no allegations about that. This is a Israeli company with all of its employees and everything located abroad, not in Virginia. There is just nothing to connect this case to Virginia except for her unilateral conduct and then speculation about whether there might have been continuing monitoring, but again, no allegations to support that at all. So, Your Honors, I'll just say a few words about the alternative argument about some subject matter jurisdiction. We think this is a fairly straightforward argument, and of course, you don't need to reach
If we
it.
agree with you and the district court that there's no personal jurisdiction, we would have no reason to address this.
Correct, Your Honor. You just took the words out of my mouth. You do not need to reach this issue. If you had any concerns with the district court's decision, though, but you would have to reach it in order to resolve the appeal, because precisely it's a question of subject matter jurisdiction. Again, Your Honor, the more they've argued that we are acting on behalf of Saudi Arabia and the Emirates on a continuing basis, the more they walk into the immunity issue. The way that we look at it, Your Honors, is that the Supreme Court has said that FISA, that's the federal statute, does not eliminate common law immunity, at least for individuals. And then this court's decision in Butters stands for the proposition that common law immunity applies to agents, not agents that qualify them, are acting in such a way that they themselves become the sovereign, an organ of the state, but for agents like an individual who's acting on behalf of the state, but not as an organ of the state itself. And in those contexts, Butters is very clear that you don't look at the nature of who, but you look at the nature of what. What is the conduct? And the only argument the district court put aside for saying that we will not apply Butters here is the idea that that was an American company in the Butters case, and this is a foreign company. And as you can see from our brief, we just don't think that's consistent with the comity that applies under the immunity doctrine, which is, if anything, the agents who are acting on behalf of the state for its benefit on foreign states are entitled to just as much immunity as anyone would be in the United States itself. And of course, we recognize that this is inconsistent with what WhatsApp has said, but of course, this court should follow the Fourth Circuit precedent, not the Ninth Circuit precedent.
Do you agree that under our precedent, there can be no immunity for acts that violate the moral norms of international law?
Your Honor, I think that's a complicated question. I'm not intending to duck it, but I do think that if you were to reach that, it wouldn't be reached on the record that's been briefed before you, because I think under Butters, it's pretty clear that at least to the extent that you're engaging as an agent, that immunity would apply. There might be a separate argument about violating norms, but that hasn't been fully briefed. It hasn't been fully presented, and we would argue it doesn't apply here in the way that the allegations have been set forth, in the sense that the allegations against us, obviously there's some terrible conduct that is being alleged, but the specific conduct relating to whether a foreign government might have cybersecurity software used to protect against criminal and terrorist activity, that is not against the international norms. So to the extent that there was more to that, it wouldn't come in at the question of subject matter jurisdiction right now, and certainly not on the record or on the allegations that are before you.
We might need to know more then to decide whether the defendants were in fact acting at the orders of a foreign sovereign, and if so, what their acts involved.
Well, Your Honor, I would say
Before we could rule on an immunity question.
Well, Your Honor, again, I would say that the problem here is in the allegations in the complaint, which is that the thinness of the personal jurisdiction allegations, and again, you can just agree on personal jurisdiction grounds, but they reinforce the lack of subject matter jurisdiction, because the only allegations here are that we licensed the product to these governments. Everything else that's happened is really focusing on Saudi Arabia and the Emirates, and there's just not enough of a connection that would allow you to to go beyond that on this complaint. So, Your Honor, I would say that I think we win the personal jurisdiction argument, but if you got to subject matter jurisdiction, I don't think there's enough in the complaint that would let you take the next step to try to decide whether this happens to violate international norms. Your Honors, obviously there's a lot in this case, but I've said more than enough. Unless you have any questions, I'd like to reserve the balance of my time.
All right, and your rebuttal would go to your cross-claim.
I assume that's what he's,
cross-appeal.
exactly, Your Honor, I assume that's what he's talking about. Thank you.
All right, thank you very much. Mr. Quirk, you've got some time to talk to us.
So Judge Agee, you asked several times for complaint allegations. Paragraph 42 at JA 16. Once Pegasus was installed on Ms. Khashoggi's phones, it granted access to all future phone calls, communication activity through apps, and text messages in perpetuity. Wherever the initial installation took place, the access continued. The access carried forward. Paragraph 46 at JA 17, a representative of defendant represents that we hear about every phone call that is being hacked over the globe. Once Pegasus was on Ms. Khashoggi's devices, the defendants continued to access the information from it. The access didn't stop with the installation. The access started with the installation.
Right,
That's
but
why
I
the
think
access
there's a
occurred.
distinction between saying or alleging that this apparatus had the capacity to enable the defendant to listen in on conversations, as opposed to saying the defendant did it.
In paragraph 46, defendants say, we did. We hear about every phone call
Well,
that
it
is
says
being hacked over the
NSO
globe.
Group stays intimately involved in the surveillance process. We hear about it. But that seems more of a generic statement and not connected to the specific facts of this case.
Well, so on a motion to dismiss, the general allegation is presumed, there's an inference that it applies to the specific instance in the case. We haven't had merits discovery to get inside their system and get all their records. We do know that our expert believed that there's reason to believe this was installed on her device, and their representation is this is what their device, what their system enables. And so that's why, based on our pleadings, our allegations that Ms. Khashoggi was in Virginia, and defendants' representations that they access everything that Pegasus accesses, they participated in the tortious acts in Virginia. On the point about the whether they automatically shut off their system when a phone is in the United States, this is where the client, the service manual we attach to the complaint is really important. We did a term search for a geographic, for a geog, for limitation. Nothing. Defendants tell the court we don't operate this system in the United States. They don't tell their clients that. We did a term search in that manual for United States specifically. Defendants tell the court we don't operate in the United States. They don't tell their clients that. I think in this instance, not operating in the United States, given what it looks like their clients were looking for, would have been an important fact, and it's not in the set of information they give about their system to their customers. That's why the court should infer the surveillance, the access to the device, and the obtaining and rerouting the communications did occur in Virginia. If I could finish back on the subject matter jurisdiction point, defendants argued that the Butters case is controlling. The fact that Butters involved a United States company acting in the United States, sued by a United States plaintiff, makes that a very different case from this one. On the remand from Cementar, in the Youssef decision, this court recognized that if common law applies, the State Department's position is important. One of the State Department's positions in that case was foreign immunity can't apply to Cementar because he was now a United States resident. The State Department's position, which this court adopted, was once you've availed yourself of the United States, your protections are now under domestic law, not foreign immunity law. Thank you.
All right, thank you very much. Mr. Parrish, do you have anything you want to add?
I'll just say two things, Your Honors. I'll be very quick. I noticed that in distinguishing Butters, I just want to say that I agree with what he said. That was a company acting in the United States, sued by a U.S. plaintiff. All those contacts here are obviously different, but what we're talking about here is the subject matter jurisdiction, and it's clear for his last point there that when the State Department has not appeared in a case or has not provided a specific opinion, that the court gets to decide that as a matter of law. That's very clear. So the issue is properly before you. Again, we don't think you need to reach the subject matter jurisdiction question. We think you can affirm on Judge Brinkham's good decision, but if you do, we would ask that you find that there is immunity under this court's precedent in Butters. And unless the court has any more questions, I thank you for your time.
All right, thank you very much. So Judge Floyd and I will come down and greet counsel, so bear with us, and then we're going to take a short recess.
This honorable court will take a brief recess.
Okay, please be seated. And we're going to hear our next case, which is U.S. versus Edwards. Mr. Carpenter.
May it please the court. This appeal presents two questions, one on the merits and one on harmless error. I'd like to start on the merits. We're asking the court to find that the 2008 conviction in this case should not have scored any criminal history points because the state judgment and the underlying state law established that the maximum possible sentence was 12 months and not 12 months plus 53 days.
How much time did he actually do?
If you look at the PSR, it looks like he did around 10 months, which I think is pretty standard for a 12-month state court sentence.
So he did that. Did he do the 53 months? I mean, the 53 days?
Yeah, it was I can grab the PSR. He served the 53 days initially, and then.
So he didn't get time off on the other sentence for the 53 days.
So it was the 10 months plus sorry, let me just be precise here. If you look at Joint Appendix page 99, probation was revoked in November. He then was released in August, which is about around 9 months plus the 53 days. So in total, he served just under 12 months of actual time by my quick math.
Well, if Mr. Edwards had not violated his probation, how would you calculate his imprisonment period?
Sure. If he had not had the sentence, if he had not violated and had the original sentence activated,
Sure.
then the calculation of his criminal history points would be governed by 4A 1.2 subsection B2, under which it says if part of a sentence of imprisonment was suspended, the sentence of imprisonment for scoring purposes refers only to the portion that was not suspended. So had there not been a violation and an activation of the full 12 months, for scoring purposes, it would have been 53 days that would have counted, which would have put him under subsection, I think it's 3, or whichever one of the C, that where you get 1 point. And again, that would have timed out in this scenario, which is why the difference is between 3 points and 4 points with the status point and 0 points, because the 53-day sentence would have been beyond the 10-year limitation.
Well, was the district court required to impose the original sentence after the revocation?
The state court,
Yes.
I don't know if it was a requirement to revoke him, but what we know, and there's nothing really in the record other than the state court judgment.
No, I mean impose the sentence after. Let me restate that. Was the district court required to impose the original sentence after the revocation?
So I think the district court, just to be precise on the language, the state court did not impose anything at the time of the revocation. What the state court did at the time of the revocation was to activate the previously imposed sentence. And to be clear, I am drawing a distinction between those two verbs, activate and impose. And I think that's what this court's opinion in Stewart did as well, because the defendant in Stewart argued that activation of a previously imposed North Carolina sentence was the same thing as the imposition.
In Stewart,
of a new
though, wasn't
sentence.
there a total suspension?
It was, yes. And we think that doesn't matter because of the rationale of what Stewart said, which was relying on the language of what subsection K says. And to quote the language in Stewart, this section, the adding methodology, applies where one offense yields both an originally served sentence and a separate revocation sentence. That doesn't apply, it says, because Mr. Stewart received only one sentence which was originally suspended but later activated. And that's what happened here. There was always one sentence in this case, the 10 to 12-month sentence. It was originally imposed. It was suspended all except for 53 days, and it was later activated, requiring him to serve the
Am I remembering
remainder.
Stewart correctly? Wasn't that, maybe I have it confused with another case, wasn't that a case where there were two separate events
Yes.
and they happened to do the sentencing on the same day? Okay.
So yes, and that takes to the point, as Stewart recognizes, a revocation has two effects on criminal history scoring. One is the aggregation effect, which is what we're talking about in this case where you total it. But what the defendant was arguing about in Stewart was the other effect of a revocation, and that's what I call the linking effect, where the revocation sentence is linked to the originally imposed sentence for purposes of the timing rules in terms of what time, when a sentence times out. And the specific issue in Stewart, the linking effect mattered for application of the single sentence rule. Because again, the defendant tried to analogize the activation of a North Carolina sentence to the imposition of a sentence, and the court said that those are separate things.
Well, the statute here seems to, the North Carolina statute refers to the term of imprisonment. A court may suspend the term of imprisonment and in addition, require the defendant to submit to a period or periods of imprisonment with relation to probation. That suggests there's two periods that we're addressing. One that is suspended, and that's Stewart and what we've been talking about. But in this special hybrid statute, the court imposes a separate period of imprisonment as a condition of probation.
Yes, Judge Rushing, if that were the way it worked, where they were actually separate, we would not be here. The reason we are here and the reason we think we have the right reading of this is that under North Carolina law, the 53-day term is part and parcel of the 12-month sentence. We know that to the extent there's ambiguity on the face of the statute itself, the court's decision, the state court decisions in the Ferris litigation answer that, both in the State Court of Appeals and the State Supreme Court, saying that any time that is served as part of the special probation is mandatory to be credited towards and as part of the
Well, does
overall
that answer the question? The fact that the court imposes two sentences, one that is suspended and one that must be served as a condition of probation, seems to be a separate question when it comes to applying the guidelines versus do you get credit for time served, which is other courts have dealt with that in the guidelines context.
Sure, and we don't dispute, again, the time served situation is different in general. What makes this North Carolina statute different than the ones at issue in cases like Merritt and Rengefo from the other circuits is that this is an activation of a previously imposed sentence as opposed to the imposition of a separate revocation sentence. And so when you read the statute as a whole, if the court is invoking the special probation provision, which it did clearly in the judgment, it requires that a term of imprisonment of some sort has to be imposed. That term cannot exceed 1/4 of the overall term, and it counts towards the sentence if it is later activated. Those are the components of state law that make this different from just an ordinary time served type of case with a revocation. And so those are the facets of state law that we think bring us to a different result here than in the out-of-circuit cases. And I think the sort of other point to make on that, we've talked sort of about Stewart, we've talked about the text of 4K, which requires the separate sentence. The third point to make on this is that the Sentencing Commission consciously drew a distinction here between ordinary revocation situations involving parole or probation and those involving judicially suspended sentences. That is the distinction that we think matters here and why the suspension here is treated differently than crediting in other contexts.
What about harmless error?
Sure. So I think that the court should find that the error is not harmless. The government has not met the burden that this court sets. And that's because this court's precedent is clear it set a clear rule, and it set that rule for a long time, that if a district court judge wants to insulate a guidelines ruling and say, look, this ruling ultimately didn't matter to my sentence, it's very easy to do so by simply saying, if I'm wrong about this, I'd give the same sentence. This court sees those types of cases all the time. There are even more of them out there where we don't bother appealing. The court did not do that here. It instead said, I would look at the same criminal history category, but of course the criminal history category is only one component of the 3553A factors, and there are other mitigating factors in this case that we think would matter in determining the size of a variance if the court was starting from the lower range, including, I think most importantly, the fact that the judge credited that the offense in this case, the escape, was not motivated by any type of criminal intent, but instead by genuine concern for that Mr. Edwards held for his daughter. We think that's a factor that would limit the scope of a variance if the court were starting from the correct range. We think that's supported by the other factors in the record as well, including the equivocation, saying that it was sort of the same result instead of exactly the same result. This court in Shivers relied on similar equivocation, where the court said it was not a significant factor. And I would highlight that, in that case, when it was remanded, there was a 14-month difference in the sentence. And again, the same thing.
What is his custody status now? I mean, is he already served it?
He is in custody now. His release date is set for May of 2025. So and that's why we had filed the motion to expedite the case to move it along a little more quickly, in hopes that if we do get a resentencing and he gets a few months off, that would be meaningful for him and could hope to be released early next year. The other point I'd make on harmless error, Judge Floyd, is that as we highlighted in the briefing, the court did not check the box on the statement of reasons form, which allows it to signal to the court that it would impose the same sentence. I think that's significant because our district court has added this box in response to this court's precedent to make it easy. Not every district has this box. I communicated with several colleagues in other districts who said they've never seen a box like this on the statement of reasons form. So I think our district court has added it for simplicity. And as the court recognized in Shivers, if the box is there and it's not checked, that's an indication that the judge doesn't intend to invoke this court's rule. I would highlight, my friend argued that it's sort of no obligation to check the box and that there are other guidelines calculations, but this is a box that you can type in additional information. I would highlight that at Joint Appendix 115, the district court typed into the statement of reasons form that he had overruled our objection on the criminal history. He could have very easily added a few more words there to say, even if I'm wrong, I would give the same sentence on that particular issue. So again, we think the standard for harmless error is very defendant-friendly. If it is a close case, we believe in essence the tie goes to the defendant to get a resentencing and let the district court make a full and fair determination starting from the correct guidelines range. Your Honor, if there are no further questions, yield the balance of my time.
All right, thank you very much, Mr. Carpenter. Ms. Ray, why don't you give us your side?
Thank you. May it please the court. Amy Ray for the United States. I'll start with the merits. The guidelines don't treat suspended sentences especially differently if they're not completely suspended. And if we look at 4A1.2B2, the guidelines say that a sentence of imprisonment means only the active portion of a suspended sentence. Mr. Edwards received a 53-day term of active imprisonment. It was imposed. That's at page 81 of the Joint Appendix. And then he received later, it was imposed a 12-month sentence. And so the guidelines say that that is to be added together. And the reason that that's defendant-friendly is that they only make one, if you are revoked, no matter how many times a defendant is revoked, you only get one number of criminal history points assessed. It could be 1, 2, or 3. But it also makes sense that if you are revoked again and again, or even just once, you have a higher number criminal history point score, potentially, than if you are never revoked. So it's a rule that makes sense in the way that the Sixth Circuit addressed it in Merritt. And while Stewart says that a suspended sentence is a revocation sentence, it doesn't have any meaningful distinction for purposes of this case, where we have a 53-day sentence imposed, and then later the year is imposed. That's what the judgments say. And this is determined by federal law. It's very clear. Miller, this court's decision in Miller holds that federal law determines how the guidelines are interpreted, not state law. And there's nothing especially unique about suspended sentences. They occur in all kinds of states. And what the guidelines say, if we apply K2, B1, B2, is here you had multiple sentences imposed, and they are added together, and when they are added together, they properly yield 3 criminal history points.
So the 53-day sentence is imposed for misconduct A. The other sentence, is it for misconduct B, or is it all a part of A?
It's when the misconduct is kind of like when somebody violates supervised release, right? It's the violation of trust. They've done something that violated probation, which is why then the suspended portion is activated or imposed, and really the activation matters for purposes of state law because they get credit for those 53 days. But for purposes of the guidelines, you have 2 judgments. One imposes 53 days and one imposes a year. And it was different conduct that required that second judgment be entered.
In other words, it is A and B.
Right.
conduct.
I think so, Your Honor. I think so. Now, I'll turn to harmless error, if Your Honors, that's sort of our basic argument on this. We have 2 judgments. B2 says a sentence of imprisonment means the active portion of the sentence, that's 53 days, and then later we have a second judgment. And I do want to just respond, I guess, briefly to one of the distinctions that Mr. Carpenter made in his reply brief about merit. There was some language in merit that said, well, this isn't a suspended sentence. If it were, it would be different. That's right, because if it were suspended in toto, as it was in Stewart, it wouldn't count at all. But it's the fact that he received an active sentence that makes this different. And the reason that Merritt and Rengifo are helpful is they establish that even if you get multiple sentences, that you never could have served that total time. In fact, in Merritt, the total time was greater than the actual days that had elapsed. It still counts for purposes of the criminal history score. Turning to harmless error, this court has recognized also for a very long time that a district court does not need to say what Mr. Carpenter suggests it needs to say, which is that it would have imposed the same sentence. That is not required, as made clear by the court's decisions in Savillon Matute, and I have no idea how that's pronounced, but that's my best guess, and Schrader. In both of those cases, the court did not say it would have imposed the same sentence. In fact, those cases are much more challenging for the government than this case because they didn't even say he would have applied the same guideline range. Here, the judge says, I would have applied the same guideline range. I would have applied criminal history category 5. And that being the same guideline range means the rest of the calculus, there's no question because he starts from that range and says, I'm going to impose a modest 6-month variance of 24 months. And he explains it using several different factors, including the fact that this defendant escaped because he was concerned that his daughter had run away. So Judge Bell did consider that mitigating factor when he determined how far to go up on the variance. But he says twice on the record it would have been the same. And the phrase sort of was, yes, thrown in there, but he says it sort of would have been the same because either way, based on your criminal history, I would have gone up to criminal history 5. And it makes sense that he would have done that. And that's also very consistent with what this court's decisions require. Shivers is different because in Shivers, the judge was specifically asked, Your Honor, would you mind saying on the record that you would impose the same sentence? And Judge Reidinger in that case declined to say that. He just said, well, the guidelines really weren't a significant factor. Now, we felt in Shivers like that was close enough to Savignon, Matute, and to Schrader, but we lost that. This is not that case because he specifically says, I would have applied the same guideline range. Addressing the box. First of all, the box doesn't have to be checked in any event. It's there. If it's checked, great. It's more helpful to the government, but there's nothing that requires that it be checked. But here's why it's not especially helpful to the defendant in this case. The judge in this case made two disputed guideline determinations. One was related to the criminal history points, the assessment of points to the fleeing to elude offense that we're talking about. The second was whether or not there should be a reckless endangerment increase. And the government argued that there should be. The defendant objected to that increase, and the judge resolved that dispute. So that box says, if I had made the guideline determinations the same, I would have imposed the same sentence. Or even if I had decided them differently, I would have imposed the same sentence. But where you have two disputed guideline determinations, a judge could very reasonably not check that box because he may think, yeah, if I had reached a different decision on the fleeing to elude, I would have gone up further, or I wouldn't have had to go up further, right? I would have just had a higher range. Judge Bell did consider that reckless endangerment. He talked about that offense conduct, that he took that Mr. Edwards took the officers on a high-speed chase through some neighborhoods in Charlotte, and he talked about that, but he just didn't check the box, perhaps because he made two disputed decisions, and had he gotten that increase, had he found that increase, he would have gone even higher. Your Honors, I'm not hearing any questions, and I think our position is pretty thoroughly set forth in the brief and what I've said so far. If Your Honors don't have further questions,
Thank you very much.
we would request that the court affirm the judgment. Thank you, Your Honors.
All right, Mr. Carpenter, do you got anything else you want to tell us?
Just a couple of quick points, Your Honor. First, my friend said correctly, there are two judgments, and that is correct in the sense there are two pieces of paper. But what matters under Section K is that there is only one sentence. And you see that if you look at the revocation judgment at Joint Appendix page 85, where it says probation is revoked and the suspended sentence is activated. So this, we believe, means that the language of Section K is not satisfied, because that language requires both an original term of imprisonment and a term of imprisonment imposed upon revocation. Here
Well,
we
I
have
thought
only-
Ms. Ray said that there was conduct A for one thing and conduct B. I don't understand that. Why aren't there two sentences?
So there are not two sentences because the state court activated the prior, activated the previously imposed sentence. And that was, Judge Floyd, the exact next point I wanted to go to was to talk about your question about misconduct A and misconduct B. Because if you look closely at the Stewart case, that's exactly what was at issue there. And because what happens is the original sentence was suspended, all except for the 53 days. He was released. He goes out and commits a breaking and entering that led to an additional charge. At the time he was arrested for that, his probation was revoked and the prior sentence was activated. So it is correct to say that the misconduct that led to the new B&E charge is what prompted the revocation.
So
However,
you have two sentences there.
you do not have two sentences, because if you had two sentences there, Judge Agee, your decision in Stewart would have come out the other way, because that's exactly the argument that the defendant in Stewart made. The facts were the same. He was sentenced on the same day.
I don't think the facts in Stewart were the same. I mean,
Well,
this was a total suspension, and
sure.
then you had,
I agree
the
with you on that
defendant had committed an A and B act,
Yeah.
and they just happened to sentence him on the same day.
Right, and what happened in Stewart, the part of it that's analogous to the back-end thing that we're talking about here, is that the defendant in Stewart was engaged in misconduct, received a new sentence for that misconduct on the same day that he was revoked and his prior sentence was activated. And the defendant argued, those are separate, that's a sentence, and it should be treated as a separate sentence for purposes of the single sentencing rule, in which case they would have married together under the single sentence rule, and he would have had fewer criminal history points as applied in that case. And what the court said is no, the revocation and the activation of the prior sentence links back to the original offense. In other words, under this weird North Carolina activation, I agree with my friend that lots of places have suspended sentences. Few places, at least according to the colleagues I've discussed, talked about this with and researched, few places do this activation procedure as opposed to the imposition of a new sentence. But regardless, that's what we think the key distinction is here, is that if you look at the face of the judgment and you look at state law, this is not the imposition of an additional sentence. It is the activation of a previously imposed sentence. And for that reason, we do not think the text of 4K is satisfied for the reasons that the court explained in Stewart.
2K said, I don't have it all right in front of me, but I got part of it.
Sure.
In the case of a prior revocation of probation, and there's some language in between, add the original term of imprisonment to any term of imprisonment imposed upon revocation.
Yes. So we think the key verb in there that makes this different is imposed versus activated. So what clearly happened here,
Well, it doesn't say activated.
that's correct, and that's why we think we win, because K says that a sentence has to be imposed upon revocation. Here, this original sentence was imposed at the time of the original judgment in July of that year. And that's, again, what Stewart gets at, is that there's a difference between imposition and activation. That is why Stewart came out the way it did.
Well, the only reason I'm pushing on it, it appears to me this is a first impression thing, and
It
I
absolutely
would
is.
like to get it right.
Yes, I agree, and that's why it is just a different scenario than the sort of serial parole or probation revocations that were at issue in the Third and Sixth Circuit cases. I mean, I credit my colleagues in those districts for coming up with an argument, but it's pretty clear why it lost, because the guidelines text is very clear in those contexts that you do the addition. This is different because of the activation, and it's exactly the language that Stewart seized on in explaining that this adding methodology doesn't apply. And I think that the one quick last point, and we made this in the briefs, is that yes, this was a total suspension in Stewart versus a partial suspension here, but the guidelines treat total and partial as exactly the same for criminal history scoring purposes. And so we think that distinction should not matter.
All right, thank you very much. We'll come down and greet counsel in this case, and then we'll move on to our last case. All right, please be seated. All right, we'll hear our next case, which is the State of Maryland et al.'s versus the 3M Company. Mr. Clement, we'll be glad to hear from you.
Good morning, Your Honors, and may it please the Court. If Maryland and South Carolina had simply sued 3M for PFAS remediation in a single lawsuit, the appropriateness of a federal forum would be obvious. A federal court would then determine not only the availability of a federal contractor defense, but whether PFAS associated with the federal activity could be separated from PFAS associated with private activity And if so, what percentage of PFAS is shielded by the federal defense? The states seem to believe that by bifurcating their claims and disclaiming any AFFF liability in one of them, they can keep that suit in state court. But that would simply transfer questions about whether PFAS from federal and private activities can be disentangled, and if so, what percentage to allocate to non-federal activities to state court. Instead of litigating the scope of the federal defense in federal court, the parties would be litigating essentially the same questions in contesting the scope of the disclaimer in state court. Federal courts, including the First Circuit just a couple of weeks ago, have rejected similar efforts to use disclaimers that stop short of foreclosing all liability for federal activities to deprive defendants of a federal forum.
Well, is it impossible to identify pollution sources once the PFAS have been commingled? I mean, is it impossible to do that, or can it be done?
We don't think it can be done, Your Honor. That is part of the allegations in our petition for removal. And part of the problem here, just to be clear, is that it's the same chemical, it's the same sort of chemical compound in the AFFF as in the non-AFFF. So it's not as if there's some way you can sort of, in the water source, figure out which one you have in some sort of definitive way. And so as a result, it's our position that we're entitled to the federal defense essentially for all of it, because if you can't disentangle it, then you're imposing liability for activities taking place under federal direction. Now, obviously, a court could disagree with us, either as a factual matter or as a legal matter, but then the next question would be, okay, how are we going to try to allocate liability from the activities taken under federal direction and the activities undertaken under non-federal direction?
I thought that was sort of your threshold argument here, that in order to make this decision, call it a causation decision between the military product and the non-military product, that decision alone belongs in a federal court.
Absolutely, Your Honor. You can think of it, in my mind, there's two questions that belong in federal court. One is more of a causation question, which is, gets to the idea of can you disentangle this at all? The other one is what I would call an allocation question. And I would say, I don't know which one's the threshold, but I'd say either one of those questions really belongs in federal court. And the reason I would say that is at the end of the day, I think that's really a question about the scope of the federal defense. And the question about the scope of the federal defense really belongs in federal court. That's part and parcel of the entitlement of somebody with federal officer removal, is to be able to litigate not just the existence of the defense, but the scope of what it protects.
So let's say we agreed with you, case stays in federal court, and in some way the experts are able to agree that 40% is military, 60% is non-military. Does the case stay in federal court at that point?
Yes.
If you could, okay.
I mean, we're entitled to essentially a federal court determination of that. Ultimately, I imagine that would be a jury question. If, in the most likely scenario. Again, I think we would be putting on experts that would say you can't disentangle it at all, so you really can't make that 60-40 determination. I assume my friends from the other side would have an expert that would say something different, but all of those contested issues belong in federal court, because at the end of the day, they really are questions about what's the scope of the federal defense in these cases. And one of the things that I do think distinguishes this from, to be sure, not from the New Hampshire and Maine cases, but from most of the federal officer removal cases, is you do have these two complaints sitting side by side. Excuse me, Your Honors. And so this is not a situation where the plaintiffs are saying, in our judgment, there's no relationship between what you did under federal officer direction and the contamination. They're saying that to a fairly well in one of their two lawsuits. And they admit that that one essentially can be in federal court. But under those circumstances, if the question is ultimately, Is the position in the removal papers plausible that you can't disentangle them, that they are commingled, and there is going to be this difficult allocation decision? Of course that's plausible. I mean, you know that from our removal papers, but essentially you know that from their other lawsuit. And this, of course, very much distinguishes this case from the case in Illinois, the Raoul case, where the state there was really focused on a single site. There's no parallel lawsuit. So they were able to make that kind of extraordinary disclaimer that not even one, we're going to try to prove this so that not even one morsel comes from the federal activity.
Well,
And
let me ask you this. It's been a while. I looked at this stuff last week, and I forgot to kind of refresh myself. Did the plaintiffs in this case, did they plead just state law claims?
I think they did plead both state law claims in both their triple F claim and their non-triple F claims.
Did they plead any federal cause of action?
I don't believe they do, and we're not here on sort of, 1331 jurisdiction. We're here on federal officer removal jurisdiction.
I understand that, but if they pled just state law claims, why aren't we applying, just at this stage, why aren't we applying the well-pled rule to keep it in state court?
Because federal officer removal is an exception to the well-pleaded complaint rule.
We don't know that yet.
What's that?
We don't know that yet because we got BP going up and we got several cases across the country going up on that issue.
Oh, I mean, with all due respect, Your Honor, I don't think there's any doubt. I think it is Willingham and a host of Supreme Court decisions make clear that you do not need for federal officer removal. The test is not the well-pleaded complaint. The whole theory of federal officer removal is that the colorable federal defense that's raised in the petition for removal is the basis for federal jurisdiction. And whatever tricky issues might be in some of these other cases, that is bedrock law. That's why these claims can be in federal court. And as I say, I don't think, my friends will correct me if I'm wrong, but for purposes of the claims being based on state law, there aren't differences between their complaint that focused on AFFF, which they accept has been removed, to federal court, and they haven't even tried to remand it. So I don't think anybody here is taking the position that these cases shouldn't be in federal court based just on the well-pleaded complaint. I think everything comes down to the removal arguments that we've made. And on that, the basis for the federal jurisdiction is the federal contractor defense. And then the question just becomes, excuse me, as was already alluded to, not just, they've essentially given away the defense in the non-AFFF cases because those are not under federal direction, but that leaves these questions of allocation and causation that still have to be decided.
Well, that's the problem in all those cases is causation, whether they can prove it or not. Even under a state law claim, causation is a big problem for plaintiffs. I understand that.
Absolutely, but the causation problem in the context of this case, it's not just a state law question. It really is a question about the scope of the federal defense, and does the federal defense cover all of what's alleged, most of what's alleged, 80%, 20%, and those are all questions that I think need to be decided in federal court because they're not just garden variety state law causation claims, though my friends take that position. I just don't think you can understand it that way. And, I think another way to try to think about these cases is it is black letter law, and I don't think my friends disagree, that if the nature of their disclaimer had simply been, we disclaim anything that's not covered by federal contractor defense, I think they would admit, well, that kind of disclaimer doesn't work because that just transfers all of the issues about the scope of the federal defense. You could say, well, no, now they're scope of the disclaimer issues, but no court has accepted that because all of the same basic issues would have to be decided in order to figure out whether What's the scope of the disclaimer? What's the scope of the federal defense? And those questions belong in state court. And really, the difference here is that my friends on the other side have tried to disclaim everything that is AFFF. And there is a slight difference between sort of AFFF and mil-spec AFFF, and it's the latter that's really covered by the federal defense. But nobody thinks that you can really carefully distinguish between those two, mil-spec AFFF and AFFF. And so what they've effectively done with this disclaimer is they said, all right, we are looking to bring nuisance claims and get an abatement for the nuisance. We're doing it statewide. We want, take Maryland as an example, we want remediation for the Chesapeake Bay and the Potomac River. But we're going to split it up between these two lawsuits, and 3M removes both of them. And my friends on the other side say, okay, well, the one that involves AFFF, even will admit that should stay in federal court, or they'll at least say we're not going to try to remand it to state court. So really the question is, can they get around that and keep half the lawsuit or one of these lawsuits in state court simply with this disclaimer? And as I've alluded to, I think our position, which I hope is clear, is that no, you can't avoid the federal court in that way, and that's principally because the causation and allocation questions remain questions about the scope of the federal defense, and those questions we have essentially an entitlement to in the federal forum. And obviously, we sent a 28J letter recently on the Express Scripts case out of the First Circuit, but that case, I think, powerfully supports the position that we're taking here today. That was a case where essentially the First Circuit credited the allegations of the defendant and essentially said that the defendant is taking the position that the federal and state activities, or the activities under federal direction and the activities not under federal direction, are indivisible. And under those circumstances, we have to credit the defendant's theory of the case. And in order to give them the federal forum that they're entitled to under the federal officer removal statute, we need to essentially allow that case to proceed in federal court. And the plaintiffs in that case will take the position, no, we can divide it or we can allocate it, but all of those questions are questions that ultimately should be decided in the federal court.
So both parties cite a prior decision of ours, Wood v. Crane, as supporting them. So why don't you give us your take on why Crane bolsters your position?
Sure. I mean, I'll start with the observation that I don't think that decision had to really squarely focus on this allocation question. And I think part of that is because you had this unusual situation in Wood v. Crane where you had valves, and the valves, ultimately, with the position of the defendant was the valves didn't have asbestos, but the valves were done under federal direction. And then there were gaskets, and the gaskets had asbestos, but they weren't done under federal direction. So there was a clear differentiation between the valves and the gaskets. And then there was a disclaimer after the case was removed to federal court, and I'll get back to that in a second, but the disclaimer there wasn't in the original complaint. It was only after the case came to federal court. And then at that point, the reason I say I don't think the court had to wrestle with the question is because everybody seemed to treat the valves and the gaskets as just being sort of very different, very discrete. And the court's ruling, obviously, was that since the plaintiffs had, once it got into federal court, disclaimed the only basis for the federal contractor defense, the federal contractor defense sort of fell out of the case. And I just want to get back to the slight difference in posture there, which I think both underscores that the court didn't definitively decide the question, but also I think is an important difference. This court was concerned in that case about the possibility of strategic disclaimers, but because the disclaimer in that case didn't occur until the case had already been removed to federal court, this court twice said, we don't have to worry about abuse here because there's discretion in the district court because there was federal jurisdiction at the beginning of when the case was removed. If the federal district court judge thinks that the disclaimer was strategic or prejudiced the defendant in some way, they have discretion to police that. And that discretion to police doesn't apply in a circumstance like this where there's a disclaimer in the original lawsuit. And so I think for multiple reasons, that decision sort of doesn't decide this case. And I think ultimately there's language in the opinion that at least we read to suggest that if you didn't have this clear bifurcation between the valves and the gaskets, then it probably would have stayed in federal court.
Okay. You've got some rebuttal time, so we'll look forward to hearing from you then. And now we'll hear from Mr. Scher.
Thank you, Judge Agee, and may it please the court. The purpose of the federal officer removal provision is to allow federal officers or their agents to present federal defenses in a federal forum. But the state courts in these cases will never address any actions by 3M for or relating to any federal conduct, nor address, or much less resolve, any federal contractor defense, because the charged conduct in these cases relates to different products, different routes of pollution occurring, and different even PFAS compounds as between AFFF contamination and non-AFFF contamination.
So the 3M parties say that you can't differentiate. This is in their notice of removal, which reverses the normal presumption in this case. And we are to take what they put in the notice of removal as true as alleged, at least at this point. And so they say, well, you can't do that, that these are indivisible injuries, and the causation question of what percentage goes to the military product, what percentage goes to the non-military product is a part and parcel of the federal officer removal statute. To make that decision itself, it's required to be in federal court.
Yes, Judge Agee, and that's their argument, and it's wrong. And the reason it's wrong is because 3M alleges only that it made mil-spec AFFF for the federal government. It does not claim it also made non-AFFF products for the federal government. So there's no way that 3M could be held liable for any official act for which it even arguably has a federal contractor defense in these non-AFFF cases.
So from a practical standpoint, just take a geographical point in Maryland on the Chesapeake Bay, where you've got a multitude of military installations all around there, and presumably other locations where the chemicals could have been used but not at a military source. And so now they're in the groundwater and they're all mixed together. How do you differentiate what goes where?
Well, Your Honor, there are tools for differentiating, but our point, the primary point here is it doesn't matter, because as all four of the district courts, 2 in the First Circuit and 2 in this circuit, have held, what the disclaimers mean with respect to the AFFF products is that the plaintiff states have assumed the burden of with respect to the non-AFFF contamination. If they don't meet that burden, either because the contamination cannot be identified as one or the other, or because there's no way of unwinding it where AFFF is present, then they lose. But they lose without anything having to do with federal defense, or federal officers, or federal direction or control. The burden and the focus...
Well, I thought the point here was that while that may be factually accurate, that the point of the federal removal statute is that it allocates to a federal court the authority to make that decision to the exclusion of a state court.
No, Your Honor, there's no case that holds that a case that is focused on non-federally related conduct, which the non-AFFF cases are, can be rewritten by a defendant because it wants to assert a defense that doesn't apply to the charged conduct in the non-federal conduct case. No
So
case says
Let me
that.
ask you a fundamental question then here. Do you agree or disagree that the PFAS injury is an indivisible injury or a divisible injury?
It's a divisible injury and it's an allocable injury, but it doesn't matter because in the hypothetical instances where there could be commingling and there could be an inability to meet the burden with respect to the non-AFFF cases, then the states, as the district court in Maine said expressly, then the states, by assuming that burden, lose on that issue. You never get to any issue of federal direction or control. They don't, my friend on the other side, doesn't contend that non-AFFF products were prepared for or by or under the supervision of any federal agency, nor that a federal contractor defense exists as to those claims, and those are the only claims raised in these states' non-AFFF cases.
Well, I don't want to be repetitive, but I want to ask the question I had to see. I think it's the same thing you're saying. Was the AFFF product, AFFF produced exclusively for the military at any time? Or was it just another product that 3M was manufacturing and the military purchased it from time to time? Is that your scenario?
No, Your Honor. So the non-AFFF case products not produced for the government ever. There's no claim that any of the compounds that are the subject of these lawsuits have any relationship to any federal conduct, any federal supervision, any federal officer direction or control. They don't relate to or arise out of any such federal nexus, nor are they subject to a federal contractor defense.
So do you assert that this AFFF stuff, that 3M made two separate products?
So let me be very clear here. If you're talking about the aqueous, I always call it firefighting foam, but it's actually...
Yeah, that's probably better to stick with that.
Okay, the AFFF. There are two kinds of AFFF. They are indistinguishable chemically. They are the subject of the MDL pending before Judge Gergel in South Carolina. And there is mil-spec, that is military specification AFFF, which is used by military installations and related facilities, and that arguably was created pursuant to federal contracts and are subject to a federal contractor defense, that issue being litigated in the MDL. There is also commercial grade AFFF, which is provided to public entities and firefighting departments and certain industries, and that is chemically indistinguishable from the military specifications AFFF and is not subject to...
So if it's indistinguishable, how is an expert going to divide it up?
Neither of those products is the subject of these lawsuits. These lawsuits relate to a wide range of products like ChemGuards, fabric, waterproofers, Teflon, a wide variety of consumer and industrial processes. They reach the environment from different sources. They reach them from landfills and public and industrial waste treatment facilities, not firefighting facilities, and they involve both different PFAS compounds and different associated compounds. So to answer to pull this back to Judge Floyd's, I think, original question, yes, experts will be able to separate the non-AFFF products in part by the differences in PFAS compounds that are in them. In fact, the Judicial Panel on Multi-District Litigation denied the motion to transfer Maryland's case to the MDL pending before Judge Gergel, in large part because it involves different products and different chemicals. And there's in the administrative record, there's the declaration of Mr. Reynolds from South Carolina, who talks about the differences in the chemical composition, both as a matter of PFASs and other compounds that allow experts to identify and allocate. But none of this matters. You can assume the truth as put forward in the notice of removal, that there may be some sites at which AFFF, mil-spec and non-mil-spec, is commingled with non-AFFF products. And even if you assume that they're correct, that you cannot allocate at those sites, what that means in these cases is that the states will not be able to satisfy their burden of proof with respect to that. And the disclaimer means that they lose on that issue. But there's no federal, I'm sorry, Your Honor.
That's getting to the point that 3M is making, isn't it? That it's not about mil-spec AFFF and consumer AFFF, that 3M is making the point that the PFAS is indistinguishable from the other products that don't contain that, and we have to look at their notice of removal and see if that's plausible. And their point is, once you're in court, to find out if the disclaimer governs a certain amount of the contamination or not, the court is going to have to, or some fact finder is going to have to allocate, well, this percentage might be coming from work done for the military, and this percentage isn't. And that very allocation gets us into something that belongs in federal court. I think that's the argument. What is your response to that?
Well, it is their argument, but it's wrong. And it's wrong for two reasons, two primary reasons. The first is you have to look at the charged conduct. If you in Express Scripts illustrates this, the charged conduct in Express Scripts was that the negotiations between the private and the federal contracts were inextricably intertwined. You could not disentangle those negotiations, and as a result, there was an availability of a potential federal preemption defense. There was a colorable defense. As to the charged conduct, the charged conduct in these cases, however, is very different. You have, on the one hand, the AFFF-related products, some of which is subject potentially to the assertion of a defense, whether it's valid or not, will be determined in the multi-district litigation. But then you have this wide variety of other PFAS compounds in other products that are factually distinguishable. And even if you assume, as I said before, even if you assume that there are some hypothetical, unidentified as of now, sites at which there's commingling and the state cannot meet its burden with respect to the non-AFFF, then the consequence of that is never the assertion of anything related to federal authority or the federal contractor defense. It simply means that the states lose. That's what the disclaimer does, and that's one of the reasons why these disclaimers are valid and not either jurisdictional disclaimers nor circular in any way.
So
What about the point that...
No, go ahead, Judge Rushing.
I was just going to ask about the abatement and mitigation, which is a request in the complaint, and the states have not disclaimed mixed PFAS sites. So what's your response to your opponent's argument that when it comes to these requests for abatement and mitigation, the whole enterprise of trying to award that relief in a mixed PFAS contamination site is inevitably going to run into this federal problem?
Well, again, it's wrong, Your Honor, and it's wrong. If you look at the disclaimer, if you look at Maryland's disclaimer, for example, which is in paragraph 13 of their complaint, which is at Joint Appendix 46, the state does not seek any remediation, restoration, damages, or any other relief related to any PFAS contamination caused by AFFF in the non-AFFF. There's a reciprocal disclaimer in the AFFF complaint. So to the extent that there might otherwise be any issue with injunctive relief in a commingled plume.
I get that on paper, but how would that actually happen if you have, one body of water that has both, the same oysters are being affected by both? You're just saying we would disclaim all abatement for that?
No, Your Honor. We would
Water?
disclaim the abatement proportional or otherwise when we get, we're a long way from the relief phase of the case, but you could do it by use of an equitable fund, for example, as South Carolina expressly pleads in its prayer for relief, and you could do it that way. I see my time is up, and I don't want to...
I have one more question for you, and that is, so I asked opposing counsel the same thing. I referred to Wood v. Crane. So I wanted to get your take on that case, or if there was another one you thought was particularly persuasive from your standpoint.
Well, the other case is the Ninth Circuit's decision in the Tyco case, because there what you had was a plaintiff who claimed his injuries was a result of handling and dealing directly with AFFF, commercial AFFF, and the defendant came in and said, well, we think your cancer was caused by drinking water that was contaminated by mil-spec AFFF, and the plaintiff disavowed the water remedy, and the Ninth Circuit said, well, the defendant cannot sustain removal on that basis. Wood v. Crane is important, I think, Your Honor, for two reasons. The first is, said that the nature of the disclaimer was clear and expressed, and that there was no reason to think that the state court would not hold the plaintiff to it.
There was no issue in Crane about an indivisible injury.
Well, there was, Your Honor. Actually, there was,
But I don't think anybody ever raised it.
Well, the defendants did in their reply brief by citing to a footnote in the defendant's brief in this court, and the first sentence in that is where the defendant says, and I'm paraphrasing, although I could have let me find the exact language. Here's the exact language I'm quoting. It is impossible to separate plaintiff's claims into separate claims on the basis of exposure to valves on one hand and gaskets on the other, unquote. That is exactly what they're asserting here, and this court said the disclaimer of the valves meant that was the disclaimer was going to be respected in the state court, even though the defendant argued that they were indivisible.
All right, thank you very much. Your co-counsel has some time.
Thank you, Your Honor.
Mr. Solomons.
May it please the court, Your Honor. Gibson Solomons for the state of South Carolina. There's a simple reason that Judge Gergel, who has examined thousands of these PFAS cases, the JPML and the District Court of Maryland all came to the same conclusion. That is, a defendant may not rewrite a plaintiff's complaint and the disclaimer contained therein to assert a defense concerning conduct falling outside the complaint to manufacture federal jurisdiction. To get to the assertion and assessment of the federal contractor defense, a plaintiff must necessarily allege that the defendant's conduct arguably protected by the doctrine caused the plaintiff's damages. In this instance, South Carolina does not make that allegation, and to make the issue crystal clear, it disclaims any recovery of damages that stem from that conduct. As to the questions raised by this court, commingling creates an issue of fact for a jury to determine what the more likely than not cause of damages are, and if appropriate, to apportion those damages. That is it. As this court stated in Anne Arundel, which you asked a question, Judge, and said, would you point to any other cases? I think the cases in the city of Baltimore and Anne Arundel are persuasive in this instance.
Well, the conduct in those cases was not the production of petroleum products. It was a separate fraud claim.
It certainly was,
And there
Your
was
Honor.
no claim there that in the production of petroleum products, there was a federal government or military requirement that you make these representations about climate. So it doesn't seem like to me that those are very close.
Well, Your Honor, you have asked a question of both counsel about indivisible damages. The inquiry has always been, is the conduct at issue indivisible? Not are the damages indivisible. The apportionment of damages is something that the trier of facts have been doing since we began having cases with multiple defendants. That's not a unique issue. And the fact that a state court may apportion damages, and a portion of that damages would be attributable to non-AFFF products, and a portion of that damages would be attributable to AFFF products, which are then excluded, does not impose or infringe upon this court's jurisdiction to assess the federal contractor defense precisely because of the disclaimer. At that point in time, the disclaimer becomes effective, and the assessment of the validity of the federal contractor defense becomes a nullity because factually the disclaimer acts as if it's proven. Now, I do want to make a correction. We have not conceded whether the federal contractor defense has application in the AFFF cases pending in the MDL. We just simply haven't gotten to that analysis. And in this case, we never will precisely because of the disclaimer. It's a factual assessment, not a legal conclusion. And they're blurring that line. I do want to make the one thing, Judge, that the reason I point to City of Baltimore and Anne Arundel is in those climate change cases, if we were looking at harm, I can't think of a more commingled harm than climate change. There's a multiplicity of factors that could weigh in as far as what is causing the climate change versus what is not causing the climate change. So that's why I point to that. I do, and I also want to point to a line out of those cases. It is the act for which the defendant is being sued, not the plaintiff's entire civil action in a general sense that must relate to the asserted federal duty. And I see I'm out of time, Your Honor.
Well, thank you very much. Mr. Clement, you've got some rebuttal time left.
Thank you, Your Honors. I think if one thing is clear from the argument today, there's a factual dispute about whether these different kinds of PFAS are divisible or indivisible. There are going to be other factual disputes about how much of this contamination in any one place is attributable to mil-spec AFFF or AFFF PFAS and other products. They're right that they're suing in this case for the other products, but that doesn't make the federal defense that we can't be held liable for the military products go away. And it doesn't make any practical difference whether you say that that allocation decision is about the scope of the federal defense or the scope of their disclaimer. I think if you just put this in practical terms, they are in this non-AFFF case, they are looking for abatement of the Potomac River and the Chesapeake Bay and the oysters and the blue crabs. Now, there's going to be a dispute about, first, whether or not these things are divisible at all, but if we get past that issue, there's going to be a dispute, and the plaintiffs are going to say, all of this has to do with the non-AFFF stuff. We get to recover, I don't know, 95%, 98% of it. It's all Scotchgard. It's all Teflon. And we're going to get up and we're going to say, no, actually, this is all because Joint Air Force Base is right there by the Potomac, and there are all these military installations right by the Chesapeake. That's why it shouldn't be 95%. Maybe it should be 80% that's covered by the federal defense. That dispute is going to happen in one court or the other. It's either going to happen in state court or it's going to happen in federal court. And the federal officer removal cases make clear that we are entitled to a federal forum to make that defense. It's going to be the same.
That's just not necessarily true. The argument has been going on. You want to be in a federal forum, and they want to be in a state forum. Why is the state court just as capable of making those decisions that you're arguing about? Because that federal officer removal statute is not absolute. And there are things that have to be proven, and why shouldn't it be done in the state court where they brought the case in the first place?
Well, the whole point of federal officer removal is the defendant gets the choice. I'm not saying that the state courts are wholly incapable of adjudicating these disputes. If we decided not to remove, then this suit could go forward. But we decided to remove. And our entitlement under the federal officer removal statute is a federal forum to adjudicate these disputes. And they're the same basic disputes. We're entitled because of the federal officer removal statute for them to take place in federal court. Now, my friend said there's no case that supports this. Well, with all due respect, he's dead wrong. The Baker case out of the Seventh Circuit is essentially on all fours, given their unwillingness to make the kind of disclaimer that the Seventh Circuit credited in the Raoul case. There you had contamination of the same things. Some of it was traceable to Freon that was produced under a government contract. Some of it came from other sources. The Seventh Circuit said repeatedly, these causation issues and allocation issues, they are issues about the scope of the federal defense. Never mind the disclaimer, they have to be adjudicated in federal court. The Express Scripts case from the First Circuit is also directly on point. With all due respect to my colleague, it was not the plaintiffs there that said this was all indivisible. That was in the notice of removal, and what the First Circuit said at great length was you have to credit the theory of the case in the removal, and you have to credit the plausible allegations in the petition for removal. Our plausible allegations are this is indivisible, and the allocation question, because of commingling, is going to be a question about the scope of the federal defense. Those issues belong in federal court. Thank you, Your Honors.
All right, thank you very much to all counsel. We appreciate your argument very much. We'll come down and greet counsel, and first I'd ask the clerk if she will adjourn court until tomorrow.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.